Under vicarious liability, one party can be liable for another's misconduct. The United States Supreme Court explored an employer's vicarious liability for sexual harassment under Title VII of the Civil Rights Act of 1964 in the case of Farragher v. City of Boca Raton. Beth Ann Farragher spent her summers working as a lifeguard for the city of Boca Raton. Farragher's supervisors were three men, Bill Terry, David Silverman, and Robert Gordon. During her 5 years working for the city, Terry and Silverman made several lewd remarks to Farragher and repeatedly engaged in uninvited and offensive touching. For example, Terry said he wouldn't promote a woman and made sexual comments, and Silverman threatened to make Farragher clean toilets if she didn't date him. Farragher told Gordon about this conduct, but he never reported it. As a lifeguard, Farragher worked at the beach and only reported to those in her chain of command. Because the lifeguards had no contact with other city officials, their supervisors had virtually unchecked authority over them. In addition, the city didn't disseminate its sexual harassment policy to beach employees, nor did it have a way for lifeguards to report sexual harassment without involving their supervisors. After resigning, Farragher sued Terry, Silverman, and the city of Boca Raton for sexual harassment under Title VII. The district court found that Terry's and Silverman's sexual harassment constituted actionable discrimination under Title VII and held the city vicariously liable. The 11th Circuit reversed in part, holding that the city wasn't vicariously liable because Terry and Silverman weren't acting within the scope of their employment when they harassed Farragher. The United States Supreme Court granted cert.